In 1957, the Dallas Municipal Courts received the highest award the American Bar Association can confer on a court system. Old-timers at City Hall proudly boast that the municipal courts have not changed in the 14 years since this plaque was awarded. 14 years without a change is some kind of a record in modern America, but hardly one which the more progressive members of the bar and the judiciary are likely to applaud. This spring, the City Council, at the instigation of Councilman Russell Smith, an attorney, took a much overdue interest in the operation of the courts. The Dallas Bar Association was asked to make a comprehensive study of the courts and to recommend changes in policies and procedures which would improve the administration of justice in municipal court. Perhaps the biggest administrative problem facing the courts is their unbalanced dockets. At any given session of traffic court, the caseloads of the different judges are unequal. One judge may have 15 cases to try, another 3, while the other 2 judges have no cases going to trial.
This is not a moving violation, won't affect your insurance.
These unbalanced dockets waste the judge's time and the taxpayers' money. In July, the City Council appointed Carl Friedlander as the new administrative judge of municipal court. Ideally, this appointment would have resolved the problem of unbalanced dockets, for in theory, the administrative judge's primary duty is to monitor the court dockets, from minute to minute if need may be, shifting cases from busy to less busy courts, in order to ensure that all cases move as quickly as possible and no judges are idle. Carl Friedlander is an administrative judge in name only. Although the City Council gave him a salary commensurate with the position, they neglected to give him any time to perform his administrative duties. Administrative judges in other cities hold court only a few hours a day, if at all. Judge Friedlander holds court 6 hours every weekday. Understandably, this impairs his ability to monitor court dockets and to undertake other reforms which are needed.
Well, ideally, the administrative judge would make sure that everything is working properly, that all the judges are carrying an equalized caseload, and that there are no problems, that he's just watches over the whole affair to make sure it's running smoothly. And at present, this is impossible. With this number of dockets, if I'm at a meeting or if I'm trying to work on something, I always keep one eye on my watch to see whether I have to get back to court to hold court, to work a docket. I am getting a secretary this week that will be answerable primarily to me and the other judges, and I'm sure that I'll be able to get a lot more work done after I get her to assist me. There are other problems, since no one has ever actively acted as an administrative judge, that we have commented on the fact that I don't even have enough filing space to file all these things, these new things that I'm trying to work on, and of course there's a filing cabinet on order. So I foresee great things in the future.
If the administrative judge is to perform his administrative duties, he must not be required to hold court 6 hours a day. Partially relieving him from his docket could require the creation of another municipal court, an expense which does not excite city officials.
Ladies and gentlemen, this is Municipal Court number 3. I'm Carl Friedlander, the judge presiding.
One cost-free change has already been implemented by Judge Friedlander. Just last week, the court procedures got a facelift designed to improve their sagging public image. In the past, courtroom procedure has been short on formality. Citizens were herded into lines to check in with the court, a procedure which caused many persons to compare the court to a collections agency. Drawing upon recommendations by the bench and the bar, Judge Friedlander concocted a short opening statement for judges to deliver at the beginning of court. This speech has 2 purposes. First, it formalizes court procedures and invests them with a semblance of judicial dignity. Secondly, it attempts to improve the traffic court's role as a force for traffic safety education.
In the clerk's office. So far this year, there have been approximately 60 persons killed, 4,500 injured, and over 18,000 accidents reported to the police department in the city of Dallas. The types of offenses that we hear in this court are the same types of cases that have resulted in some of these deaths, injuries, and accidents. For this reason, we hope that none of you here today will become part of our traffic statistics in the future. Now the bailiff will call the cases.
These 4 books constitute the law library of one municipal court judge. Ironically, the city budget provides law libraries for the city prosecutor's office and the police department, but no money is allotted for the judges who must apply and interpret the laws. A judge is expected to use the city attorney's library or pay for whatever reference books he feels he must have. This judge's personal library is the most extensive one I saw, and even it is sorely inadequate. Judges need their own law library because they deal with 2 complex and constantly changing areas of the law, traffic laws and the criminal law. The idea of each judge providing his own library is not economically feasible, and the notion that judges should use the city attorney's library presents 2 problems. First, it is inconvenient. The long trek to the city attorney's library, located in another part of the building, is time-consuming. Moreover, the library is closed at night when night courts are in operation, and other judges would have time to do legal research. Secondly, spending time in the prosecutor's library hardly contributes to judicial impartiality. Upon appointment, Judge Friedlander attempted to submit a budget request for a law library. What happened to that request further illustrates the problems facing the administrative judge. The provision creating the administrative judgeship fails to define his responsibilities, giving him no clear-cut role in the budget-making process. That budget request never reached the city budget office. It was held up by the court clerk, who felt the money could be diverted from another fund. Such is not the case. However, there may be law books for the judges this fall. Sources in City Hall indicate that the money will come from the city attorney's office. In the past, the municipal courts have been the stepchild of city government. There has been no one to articulate the court's needs to the city council, and few on the council willing to take on the job of initiating reform. Hopefully, the current concern of the council, the bar, and the municipal judges themselves will result in changes in the courts which will improve their public image and their operational efficiency.